Generally, Australian law treats each company as a separate legal entity, meaning a holding company is not automatically liable for the debts of his subsidiary. This principle of limited liability allows corporate groups to structure their operations so that financial and legal risk is contained within individual entities. However, this protection is not absolute. There are important exceptions where a holding company can become liable for a subsidiary's debt. One key exception arises where a holding company provides contractual guarantees or indemnities for the obligations of its subsidiary. If the subsidiary defaults, the holding company may be required to meet those liabilities in accordance with the terms of the guarantee. Another major area of risk is insolvent trading. A holding company may be liable where a subsidiary incurs debts while insolvent or becomes insolvent by incurring those debts, and the holding company or its directors knew or ought reasonably to have suspected that insolvency existed. In these circumstances, liquidators may pursue the holding company for compensation. Liability can also arise where a holding company is directly involved in the subsidiary's misconduct, including misleading deceptive conduct, or where the holding company effectively controls and directs the subsidiary's operations in a way that blurs the separation between the entities. In rare cases, courts may also pierce the corporate veil where the corporation structure is used to perpetuate fraud, evade legal obligations, or operate as a sham, allowing liability to flow up to the holding company. Because the financial consequences can be significant, careful corporate structuring, clear governance, and disciplined financial oversight are essential to manage holding company exposure and preserving limited liability protections. Contact us today for a free 30-minute consultation with one of our experienced team of debt recovery professionals, and let us help you protect your rights.